Welcome to the Legal Masterminds podcast. This is where sharp minds meet sharp law. We break down landmark cases, teach strategy, and keep you steps ahead. Whether you are a lawyer, law student, legal intern, or just someone who loves smart conversations. Inside this podcast, we do not just talk law, we unlock it. Want to join the community behind this podcast? Send us a DM. We promise you will love it here. Now let us get into today's case.
This is a summary of Chukwuka Okoronkwo versus Independent National Electoral Commission, a decision of the Supreme Court of Nigeria delivered on the 7th of February, 2025. Okoronkwo joined the Independent National Electoral Commission, INEC, in the year 1989. Okoronkwo was an administrative officer. On the 13th of September, 1997, INEC suspended Okoronkwo from duty. The suspension came by letter and took immediate effect. Okoronkwo believed the suspension was unlawful. Okoronkwo felt it was unjustified and without due process. But Okoronkwo waited. It was not until April 2000 that Okoronkwo filed a suit at the Federal High Court. By then, nearly 3 years had passed. In the suit, Okoronkwo sought four reliefs. First, a declaration that the suspension was invalid. Second, reinstatement to the former position. Third, full payment of all withheld salaries and benefits. Fourth, general damages of 1 million naira. INEC responded swiftly. The defense by INEC was simple. The case, INEC argued, had been filed too late. Under the Public Officers Protection Act, POPA, suits against public officers must be brought within 3 months from the date of the alleged wrong. The claim, INEC said, was already dead on arrival. The Federal High Court delivered judgment in 2005. The Federal High Court ruled in favor of Okoronkwo. The Federal High Court granted all the relief sought. The Federal High Court found that the suspension was unlawful. The Federal High Court ordered reinstatement and awarded the full 1 million naira in damages. INEC appealed. At the Court of Appeal in 2009, the decision changed. The Court of Appeal held that the Federal High Court had overlooked a crucial fact, the delay. The Court of Appeal found that the case was clearly filed outside the 3-month limit set by the Public Officers Protection Act. The suit, the Court of Appeal said, was statute barred. The Federal High Court lacked jurisdiction from the outset. Okoronkwo took the matter to the Supreme Court. At the Supreme Court, Justice Solewa delivered the lead judgment. Justice Solewa stated that the cause of action arose on the 13th of September, 1997, the day INEC issued the suspension letter. That date triggered the limitation period. The 3-month clock began to run on that day. Filing the suit in April 2000, more than 2 years later, was far too late. According to the Supreme Court, once the statutory window closed, no court could revive the claim. Even the strongest claims must fall if filed out of time. Before the Supreme Court, Okoronkwo argued that the suspension caused continuing injury. Okoronkwo claimed the harm did not stop on the day of suspension. Okoronkwo said the harm followed month after month. Each withheld salary, each missed promotion, was a fresh violation. But the Supreme Court disagreed. The Supreme Court explained that the legal wrong was the suspension itself. The suspension was a single, completed act. The consequences that followed were effects, not new wrongs. In legal terms, there was no continuing injury. The suspension occurred once. The cause of action was complete on that day. The next question was whether the Public Officers Protection Act applied to employment cases. The Supreme Court answered yes. The Supreme Court held that POPA covers suits arising from employment relationships, especially when the employer is a public authority acting under statutory powers. The Supreme Court identified 3 types of employment. 1. Employment at the employer's pleasure. 2. Master-servant arrangements. 3. Statutory employment regulated by law. INEC fell into the third category. As a statutory body, INEC was acting under public authority when INEC suspended Okoronkwo. This attracted the protection of the Public Officers Protection Act. Several justices of the Supreme Court gave concurring judgments. Justice Sankey stated that the Public Officers Protection Act exists to shield public authorities from endless distraction and needless litigation. Justice Ogbinia added that statutory employment is distinct from private contracts. When public bodies act under the law shields them. Justices Adumain and Umar agreed with the reasoning. The Supreme Court stressed that limitation laws are not technical rules. Limitation laws exist to promote fairness and legal certainty. When litigants delay, evidence disappears. Memories fade. Witnesses vanish. Limitation periods protect both sides. Here are the legal principles reaffirmed by the Supreme Court in this case. First, the cause of action arises when the wrongful act occurs, not when effects continue. Second, when the limitation period expires, courts lose jurisdiction. No matter how strong a claim may be, the claim must fall if filed out of time. Third, the Public Officers Protection Act applies to statutory employment. Once a public authority acts under statute, the protection applies. Fourth, continuing injury does not arise from a single, completed act. Time begins to run from the act, not the aftermath. Fifth, the court will not assist an indolent party. Delay extinguishes remedy. Okoronkwo vs. INEC is a serious reminder. Ensure you approach the court on time. The decision, however, raises serious concerns. 1. Is INEC, being a statutory body, a public officer under the Public Officers Protection Act or under the Constitution? 2. Did INEC take an oath of office, as required of public officers? If the answers to these are no, how then can INEC, a non-public officer under both the Public Officers Protection Act and the Constitution, take shield under POPA?
Hope you enjoyed this case. Now imagine having access to minds that break down the law like this every single week. Why not join our Legal Masterminds community today? We do more than analyze cases. We build legal giants. One thing we promise you, you will stay up to date with Nigerian law, master powerful legal strategies, and connect with people who think just like you. Our next meeting is this coming Saturday at 8 p.m. West African time. We are always prompt, no delays. Send us a DM to join. The seat is yours if you are ready. Till next time, stay learning, stay bold, stay sharp.